The principle of separation of powers is a constitutional law doctrine that divides a democratic state's government into three branches: the legislature, the executive, and the judiciary. 1. Legislative creates laws and statutes. 2. Executive enforces laws created by the legislature. And 3. Judicial reviews the actions of the other two branches. The principle of separation of powers is also known as the system of checks and balances. It's based on the idea that each branch acts as a check on the others, preventing any one branch from gaining too much power. This separation of powers is essential to a healthy democracy and helps to prevent abuses of power. The principle of separation of powers implies that 1. No person should hold more than one position in the government. 2. No branch of the government should exercise the functions of another branch. And 3. No branch of the government should interfere with the functions of the other two branches. The term, separation of powers, is also used in business to describe when different positions have distinct areas of oversight and decision-making. The Indian Constitution does not strictly adhere to the principle of separation of powers, but it does include some provisions that promote it. 1. Article 50 states that the state should take steps to separate the judiciary from the executive. 2. Criminal Procedure Code, 1973, separates the executive and judiciary by assigning the police to investigate crimes and the judiciary to adjudicate cases. 3. Articles 361, 1, and 2 grant immunity to the President and governors from court proceedings to avoid interference from the judiciary. And 4. System of checks and balances. The judiciary has the power to strike down unconstitutional laws passed by the legislature. The separation of powers principle is intended to 1. Ensure that democracy and liberty are not empty promises. 2. Protect citizens and the state from encroachment. 3. Prevent any one branch of government from dominating the other. And 4. Remove the abuse of power by authorities. However, it's impractical to have a strict separation of powers in most constitutional systems. In India, conflicts and transgressions by one branch over another often arise. The doctrine of separation of powers is not explicitly stated in the Indian Constitution, but it is incorporated in an implied manner. 1. Article 50 states that the state should take steps to separate the judiciary from the executive to ensure the judiciary's independence. 2. Checks and balances. The powers of the organs of the government overlap, creating a system of checks and balances. 3. Functions of the organs. The Constitution specifically mentions the functions of the three organs of the government. And 4. Legislative cannot pass violating laws. The legislature cannot pass a law that violates the principle of separation of powers. The doctrine of separation of powers was first formulated by French writer Montesquieu in his 1748 book Esprit de Lois. The doctrine's main objective is to ensure that the government is run by law, rather than by the whims of officials. Here are some examples of how the powers of the organs of the government overlap in India. 1. The Council of Ministers, Executive, are part of the Parliament, Legislature. 2. The President, Executive, has the power to promulgate ordinances, which is a legislative function. 3. The Legislature has the power to exercise some judicial functions. 4. The judiciary is granted certain legislative and executive powers. And 5. The executive exercises quasi-judicial powers through the setting up of tribunals.